the state.
State will call Bonnie Jameson.
We're going to object based on the same grounds previously stated.
Thank you, sir. I will let the record reflect this witness has been sworn. You've been sworn, that's fine.
Good morning, Bonnie.
Good
Just one
morning.
more time for the record, go ahead and say your name.
Bonnie Jameson.
Now, Bonnie, you know this jury has convicted the defendant of capital murder, and they have some things to consider now. And I want you to go ahead and tell the jury.
Mr. Lord, you need that microphone, please.
Bonnie, I want you to tell the jury how this crime has impacted your life.
Actually, I feel like I've been sentenced myself. I seek counseling continually. I go to counseling because I am constantly reliving the garage scene, myself personally. Since the incident, the nightly nightmares, the dreams, the waking up, seeing the terror in Kinder's face in that car, that plays over and over and over in my head. I can't dismiss it. So for 3 years I've been going to counseling to deal with that. That's been the biggest thing for me, is that parking garage. And I was in that parking garage with her several times. The first time I came out to visit her in Dallas, and
Bonnie, I want you to kind of explain and talk to the jury about how it's changed your life, and going forward, how is this impacting your life?
I'm a small businesswoman myself. I have a quilt shop that I've owned and operated for 20 years back home. And honestly, the quilt shop is I thought I was going to have to give it up after this, but I've continued working my shop because it's the only place that I can actually go to feel normal. All my customers that come in and greet me every day, they've all became family. I mean, not only has it affected friends and family, it's also affected my retail business and my customers. So that's my normalcy now, is going to work. I don't stay home. I can't. If I was to stay home and dwell on this every day, I would be right with Kendra. But I had to choose to carry on, as well as my family. We have a choice. Unlike choices that other people make, we feel like we do the best we can by making the right choices. So.
Bonnie, thanks for answering my questions. You're going to pass the witness.
Thanks.
Thank you.
Ms. Jameson, you may stand.
Thank you.
Stay rest.
Close.
Yes, close.
All right, members of the jury, you have heard all the evidence that you will in the punishment phase of the trial. I will now again read to you the charges before the punishment phase. If your argument of counsel, and then you're retired to the record. May I see the lawyers at the side of the charge of the court. By your verdict, you have found Kristopher Love, the defendant, guilty of the offense of capital murder alleged to have been committed on or about September the 2nd, 2015, in Dallas County, Texas. It is now your duty to determine from all of the evidence in the case answers to certain questions called special issues. You are instructed that the punishment for the offense of capital murder is either death or confinement in the institutional division of the Texas Department of Criminal Justice for life without parole. Two special issues, numbered 1 and 2, are included in this charge. You are instructed to answer these special issues either yes or no in accordance with the instructions given in this charge. Special issue number 1. Do you find from the evidence beyond a reasonable doubt that there is a probability that the defendant, Kristopher Love, would commit criminal acts of violence that would constitute a continuing threat to society? Special issue number 2. Do you find, taking into consideration all of the evidence, including the circumstances of the offense, the defendant's character and background, the personal and moral culpability of the defendant, Kristopher Love, that there is a sufficient mitigating circumstance or circumstances to warrant that a sentence of life imprisonment without parole rather than a death sentence be imposed? In deliberating on your answer to special issue number 1, you are instructed that the state has the burden of proving beyond a reasonable doubt that special issue number 1 should be answered yes. If you do not find and believe from the evidence beyond a reasonable doubt that the answer to special issue number 1 should be yes, or if you have a reasonable doubt thereof, then you shall answer special issue number 1 no. You shall consider all of the evidence admitted during the guilt-innocent stage of the trial and the punishment stage, including all evidence of the defendant's background or character or the circumstances of the offense that militates for or mitigates against the imposition of the death penalty. You may not answer special issue number 1 yes unless the jury agrees unanimously, and you may not answer special issue number 1 no unless 10 or more of members of the jury agree. The members of the jury need not agree on what particular evidence supports a negative answer to special issue number 1. If you have answered no to special issue number 1, then you shall cease your deliberations. If you have answered yes to special issue number 1, then you shall consider next special issue number 2. If you answer that a circumstance or circumstances warrant that a sentence of life imprisonment without parole rather than a death sentence be imposed, the court will sentence the defendant to imprisonment in the institutional division of the Texas Department of Criminal Justice for life without parole. A defendant sentenced to confinement for life without parole is ineligible for release on parole. In deliberating on your answer to special issue number 2, you are instructed that you may not answer special issue number 2 no unless the jury unanimously agrees, and you may not answer special issue number 2 yes unless 10 or more of the members of the jury agree. The members of the jury need not agree on what particular evidence supports an affirmative answer to special issue number 2. In arriving at your answer, you shall consider mitigating evidence to be evidence that a juror might regard as reducing the defendant's moral blameworthiness. You are instructed if the jury answers yes to special issue number 1 and no to special issue number 2, the court shall sentence the defendant to death. If the answer is no to special issue number 1 or the answer is yes to special issue number 2, then the court shall sentence the defendant to confinement in the institutional division of the Texas Department of Criminal Justice for life without parole. If the jury's answers to special issue number 1 and 2 are unanimous, then the presiding juror may sign each special issue for the entire jury. If the answer or answers are not unanimous, but agreed to by at least 10 members of the jury as set out above, then the 10 or more jurors who agree shall individually sign the special issue. During your deliberations upon special issues, you must neither consider, discuss, nor relate any matters not in evidence before you. You shall not consider nor mention any personal knowledge or information you may have about any person or fact connected with this case which is not shown by the evidence. In arriving at the answers to the special issues, it will not be proper for you to fix the same by lot, chance, or any other method other than by a full, fair, and free exchange of opinion of each individual juror. You are not to be swayed by mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling in considering all the evidence before you and answering the special issues. In determining your answers to the special issues, you shall consider all the evidence submitted to you in the whole trial, which includes the phase of the trial wherein you were called upon to determine the guilt or innocence of the defendant, and this punishment phase of the trial where you're now called upon to answer the special issues submitted to you by the court. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain evidence might be properly admitted. Do not be concerned for the reasons for such rulings and draw no inferences from them. Whether or not evidence is admissible is a question of law. In admitting evidence to which an objection is made, the court does not determine what weight should be given such evidence, nor does it pass on the credibility of the witness. As to any offer of evidence that has been rejected by the court, you of course must not consider the same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been or as to the reason for the objection. You are instructed that you are not to allow yourselves to be influenced by, in any degree whatsoever, by what you may think or surmise the opinion of the court to be. The court has not intended to express any opinion on any matter of fact in this case, and if you have observed anything which you have or may interpret as the court's opinion upon any matter of fact in this case, you must totally disregard it. You are instructed that if there is evidence before you in this case regarding the defendant having committed an offense or offenses other than the offense alleged against him in the indictment, you cannot consider this evidence for any purpose unless you first find to believe beyond a reasonable doubt that the defendant committed such other offenses, if any were committed, and even then you may only consider the same in determining the answers to the special issues. You are further instructed that you are not to consider the defendant's guilt for the charged offense of capital murder as any evidence that the defendant did, in fact, commit any other offenses beyond a reasonable doubt. You are further instructed that the law allows the defendant to testify in his own behalf at this phase of the trial, but a choice on his part not to do so is not a circumstance against him, and no presumption can be indulged in by the jury for that choice on his part not to do so. During your consideration of this case, you are not to consider, discuss, or even refer to the defendant's choice not to testify. After the reading of this charge, you shall not talk with anyone not of your jury. After argument of counsel, you will retire to consider your answers to the special issues submitted to you. It is the duty of your foreperson to preside in your jury room and vote with you on the answers to the special issues submitted. You are the exclusive judges of the facts proved, and the credibility of the witnesses, and the way to be given the testimony that you are bound to receive the law from the court, which is here and given you and be governed thereby. Again, it's signed by me, Tracy Holmes. And the final pages are the verdict forms. Special issue number 1, there's a line for the answer and the foreperson's signature if it's unanimous. If it is not unanimous, for the 10 or 11 jurors to sign. And the same with special issue number 2, if it's unanimous, a signature line for the presiding juror or signature lines for the 10 or 11 jurors who disagree. Mr. Brooks?